Hello and welcome to our today's lecture on position and powers of Karta or manager of Hindu joint family. Aim of this lecture is to acquaint you with the Hindu joint family system. We will discuss the position of manager of joint Hindu family called Karta, his liabilities and powers under Hindu law. In the entire Hindu joint family, the Karta or manager occupies a very important position. So unique is his position that there is no office or institution in any system of the world which can be compared with it. His position is sui generis. He is a person with limited powers, but within the ambit of his sphere, he possesses such vast powers as are possessed by none else. It is a presumption of Hindu law that ordinarily the senior most member is the Karta of the joint family. The senior most male member is Karta by virtue of the fact that he is the senior most male member. He does not owe his position to agreement or consent of other co-partners. So long as he is alive, may be aged, infirm or ailing, he will continue to be the Karta. Even a leper may continue to be the Karta. Whether insanity or any other disqualifications will defeat his right is not clear, but it seems that in such a case, the next senior male member will take over the Kartaship. Once this is done, the former will cease to be a Karta. So long as the father is alive, he is the Karta. After his death, it passes to the senior most male member, who may be the uncle, if co-partnery consists of uncles and nephews, or who may be the eldest brother if co-partnery consists of brothers. In the presence of a senior male member, a junior member cannot be the Karta. But if all the co-partners agree, a junior male member can be a Karta. The junior member owes his appointment to the agreement or consent of the co-partners. Co-partners may withdraw their consent at any time. Female members can act as Karta. The Nagpur High Court held the view that mother, though not a co-partner, can be, in the absence of adult male members, Karta of a joint family, and her acts will be binding on others as that of a Karta. The Supreme Court in Commissioner of Income Tax versus Seth Govindram, 1966, after reviewing the authorities, took the view that the mother or any other female could not be the Karta of the joint family and therefore cannot alienate joint family property. This is in accordance with the texts of Hindu law. According to Hindu sages, only a co-partner can be a Karta. Since females cannot be co-partners, they cannot be the Karta of the joint family. In Ganguly versus H.K. Chennappa, the Karnataka High Court expressed the view that the mother, as natural guardian of her minor sons, can manage the joint family property, and appointment of a guardian by courts will not be justified. This is obviously the situation where the father is dead and there is no adult male member. After coming into force of Amendment Act of 2005, a woman, since is now a co-partner, there is no bar of her being a Karta. Let us discuss the position and liabilities of a Karta. The position of Karta is sui generis. The relationship between him and other members are not that of principal or agent or partners. He is not like a manager of a commercial firm. Needless to say, he is the head of the family and acts on behalf of other members. But he is not like a partner, as his powers are almost unlimited. His powers of management are so wide and almost sovereign that any manager of business firm pales into insignificance. In a sense, he stands in fiduciary relationship with other members, but he is not a trustee. Ordinarily, he is accountable to none. Unless charges of misappropriation, fraud, or conversion are levelled against him, he is the master, and no one can question him as to what he received and what he spent. So long as he manages the affairs of the family, he is not bound to save, economize, or invest. In short, he is not liable for his positive failures, such as failure to invest, to prepare accounts, or to save money. He is not bound to pay the income of the joint family in any fixed proportion to other members. Even if he enters into such arrangement, he can repudiate it with impunity. He is not bound to treat all members impartially. He may discriminate. He has liabilities towards members. Any co-partner can, at any time, ask for partition. He obtains no reward for his services, and he discharges many onerous responsibilities towards the family and its members. His true legal position can be understood only when we know the ambit of his powers and liabilities. Karta's liabilities are numerous and multifarious. The Karta of the joint family is responsible to maintain all members of the family, co-partners and others. If he improperly excludes any member from maintenance or does not properly maintain them, he can be sued for maintenance as well as for arrears of maintenance. He is also responsible for the marriage of all unmarried members. This responsibility has been particularly emphasized in respect of daughters. If a partition suite is filled, he has to prepare accounts, though this has different meaning under the Daya Bhaga and the Mitakshara schools. The Karta represents the family. He is its sole representative vis-a-vis the government and all outsiders, and in that capacity, he has to discharge many responsibilities and liabilities on behalf of the family. He has to pay taxes and other dues on behalf of the family, and he can be sued for all his dealings on behalf of the family with outsiders. Powers of Karta. When we enumerate the powers of Karta, the real importance of his legal position comes into clear relief. His powers are vast and limitations are few. The ambit of his powers may be considered under two heads. Number one, power of alienation of joint family property, and number two, other powers. In the former case, his powers are limited. As a general rule, he has no power of alienation. He can alienate properties in exceptional cases only. In the latter case, his powers are very large, almost absolute, though in respect of incurring debts, his powers are again restricted. Powers of management. As the head of the family, Karta's powers of management are almost absolute. He may manage the family affairs and family property and business the way he likes. No one can question his management. The Karta has no obligation to save or economize, no obligation to invest funds or to invest them properly. For instance, he may not lease out family property, or he may lease it out at a nominal rent. He may discriminate between the members of the family. To some, he may give more to spend, to some less. Some may be given higher education, while others may be given only primary education. To some, he may allot a bigger portion of the house to live in. To some, he may allot a smaller portion. But he cannot deny maintenance or use and occupation of property to any co-partner. Then, the ever-hanging sword of partition is a great check on his absolute powers. Right to income. It is the natural consequence of joint family system that the whole of the income of joint family property, whosoever may collect them, a co-partner, agent or a servant, must be handed over to the Karta unless he has specifically allotted income of a particular property to a member. It is a rule of the Mitakshara joint family that no member of the joint family is entitled to any definite share of the income of the joint family property or business. It is for the Karta to allot funds to the members and to look after their needs and requirements. So long as the family remains joint, no member can ask for any specified share in the income. Right to representation. The Karta of the joint family represents the family in all matters, legal, social, and religious. He acts on behalf of the family, and his acts are binding on the entire joint family. The joint family has no corporate existence. It acts in all matters through its Karta. The Karta can enter into any transaction on behalf of the family, and it will be ordinarily binding on the joint family. merely because one of the members of the family also joins him in the representation does not alter the position of the Karta or the binding character of the transaction so entered into by the Karta. He also represents the family in suits and other legal proceedings. The joint family will be bound by a decree or order passed in legal proceedings. Even when the Karta has lost a case on account of his gross negligence, it is not open to other members to have the decree set aside on that ground alone. Power of compromise. The Karta has power to compromise all disputes relating to family property or their management. He can also compromise a suit pending in a court, and it will be binding on all the members, though a minor co-partner may take advantage of 32 Rule 7 CPC, which lays down that in case of one of the parties to the suit is a minor, the compromise must be approved by the court. Power to refer a dispute to arbitration. The Karta has power to refer any dispute to arbitration, and the award of the arbitrators will be binding on the joint family if valid in other respects. Power of acknowledgement. The Karta has power to acknowledge on behalf of the family any debt due to his family. He has also the power to pay interest on a debt or to make part payment of the principal so that a fresh period of limitation may start. But the Karta has no power to acknowledge a time-barred debt. Karta's power to contract debts. The Karta has an implied authority to contract debts and pledge the credit of the family for ordinary purpose of family business. Such debts incurred in the ordinary course of business are binding on the entire family. The Karta of the non-business joint family also has the power to contract debts for family purposes. Such debts are binding on the members of the joint family. When a creditor seeks to make the entire joint family liable for such debts, it is necessary for him to prove that the loan was taken for family purposes, or in the ordinary course of business, or that he made proper and bona fide inquiries as to the existence of need. The expression family purpose has almost the same meaning as legal necessity, benefit of estate, or performance of indispensable and pious duties. Just as alienation is justified for legal necessity, etc., a debt is also justified for the same purposes. Loan on promissory note. When the Karta of a joint family takes a loan or executes a promissory note for family purposes or for family business, the other members of the family may be sued on the note itself, even if they are not parties to the note. Their liabilities are limited to their share in the joint family property, though the Karta is personally liable on the note. This distinction between liability on the note and liability on the debt is very material. If liability is on the note, the consideration in certain circumstances will be presumed, while if liability is on the debt, it would be necessary to prove that the debt was taken for a purpose binding on the family. Power to enter into contracts. The Karta has power to enter into contracts, and such contracts are binding on the family. It is also now settled that a contract, otherwise specifically enforceable, is also specifically enforceable against the family. Power of the Karta of the trading joint families. The Karta of the trading family has all the powers of the Karta of an ordinary family. He has additional powers. For instance, the Karta of the trading family can take debts in the course of business. For such debts, except the Karta, no one else is personally liable. Their liability extends only to the extent of their interest in the joint family property. It has been held that the joint family is also liable for the torts of the Karta committed in the course of business. Karta's power of alienation. Although no individual co-partner, including the Karta, has any power to dispose of the joint family property without the consent of all others, it is recognized by the Dharma Shastra that in certain circumstances, any member of the family has power to alienate the joint family property. Thus, Mitakshara recognized three exceptional cases in which alienation of the joint family property could be made. Number 1, in the time of distress. Number 2, for the sake of the family or for the maintenance of the members of the family. And number 3, for the performance of indispensable duties. Hence, the joint family property can be alienated for the following purposes. First, legal necessity. This includes acts for the sake of the members of the family. Second, benefit of estate. This acts include for the sake of family property. And number 3, acts of indispensable duty. This includes the entire head of religious duties. It is now settled that the Karta can alienate the joint family property with the consent of the co-parceners, even if none of the above exceptional cases exist. If all the co-parceners are adult, it is binding on the entire joint family. The actual compelling necessity is not the sole test of the validity of an alienation made by the Karta. Thus, legal necessity does not mean actual compulsion. It means pressure upon the estate which in law may be regarded as serious and sufficient. If it is shown that the family's need was for that thing or that article, and if property was alienated for the satisfaction of that need, it would be enough. The term is to be interpreted with due regard to the conditions of modern life. However, when there is no proof that the business is the family business, any loan taken for a business by the Karta cannot be said to be for binding necessities or for the benefit of the estate. Any enumeration of the cases of legal necessity cannot be exhaustive. With this caution, we may note some illustrative cases of legal necessity. A. Food, shelter and clothing for the members of the family. B. Marriage of the members of the family including daughters towards whom there is a special duty. Further debt incurred for the marriage of a minor in violation of Child Marriage Restraint Act 1929 being unlawful and against public policy cannot be a legal necessity. C. Medical care of the members of the family. D. Defense of a member involved in a serious criminal charge but not for the prosecution of a person accused of murdering a member of the family. E. For the payment of debts binding on the family and for the payment of decretal debts. F. For the payment of government dues such as land revenue, income tax case and other taxes and duties. G. For the performance of necessary ceremonies. H. For the payment of rent. I. Sale of land to construct a pakka house. J. Alienation by the Karta to purchase agricultural implements where the family was engaged in agriculture was held to be for legal necessity. Benefit to estate. Broadly speaking, benefit of estate means anything that is done which will benefit the joint family property. The Privy Council in Palinaipa versus Devsky Moni 1917 observed, "It is impossible to give a precise definition of its applicability in all cases. The preservation, however, of the estate from extinction, the defense against hostile litigation affecting it, the protection of it or the portions from injury or deterioration by inundation, these and such like things would obviously be benefits." The view that anything done which is of positive benefit to the estate would amount to benefit of estate. The test is of a prudent owner. Anything which a prudent person can do in respect of his own property, the Karta can do in respect of the joint family property. A full bench judgment of the Bombay High Court in Hemraj versus Nathu 1935 took an intermediate view. The property cannot be alienated merely for the purpose of enhancing its value, though at the same time it would not be correct to say that no transaction can be for the benefit of estate which is not of a defensive character. The judicial opinion has come in favor of the test of prudent person. This implies that the Karta cannot convert family property into money just because the property does not yield any income without replacing it with some more advantageous property. Property belonging to a joint Hindu family, ordinarily, as long as the family is undivided, remains with the father, if alive or in his absence by other senior male member of the family for the time being. The person who thus manages is called its Karta. The Karta of the joint Hindu family is certainly the manager of the family property, who undoubtedly possesses powers which the ordinary manager does not possess. A co-partner who is the manager or Karta has no longer proprietary interest in the family property, nor has he larger rights to enjoy than any other co-partner. He is also not entitled to any remuneration. With this, we come to the end of our today's lecture. Hope you enjoyed and have a good day.